We are all aware of our fundamental rights and the rights provided to us under the Constitution of India. However, today we are going to discuss writs, the law of writs, and how writs are used to protect our fundamental rights. The Constitution of India has provided us with two major provisions for writs. One is Article 32, which provides us a very fundamental right in moving the Supreme Court of India in writ jurisdiction. The second is Article 226, which provides us the right to move any High Court of State for violation or infringement to our fundamental or constitutional rights. Before we move on to the type of writs and how to use the writ provisions, let us first understand what is a writ. To understand more particularly what is a writ, we take the definition provided to us by the Black's Dictionary, which says, it is a court's written order in the name of a state or competent legal authority commanding the addressee to do or to refrain from doing some specific act. Now let us understand this more particularly. It's a court's written order addressed to the addressee, directing him to either do something, that means where he is required to do something, he is being directed by a court of law to do it or to perform such act, and where he is going beyond the scope of his jurisdiction or where it is going beyond legal permissible limits, then to refrain from such act. Well, as most of us know, there are 5 types of writs, namely habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Now let us take each of these writs individually and see what protection they offer us. Let's take the first one, habeas corpus. Habeas corpus literally would mean let us have the body. Now, what is the meaning of this? This is a writ that is used in cases where a person is being held in detention or imprisonment is of an illegal nature, where a writ can be filed and the court would direct the detaining authority to produce the person so being held before that court. And then the validity of that detention would be discussed. In the case of a habeas corpus, who could file for it? Either a relative or a friend of a person that is being illegally detained or imprisoned. The next writ is the writ of mandamus. The writ of mandamus would literally be translated as a mandatory direction or we command. Now, when does this lie? This writ is a very commonly used writ when authorities of the state or the government or mechanisms of the government fail to perform their statutory duty, fail to enforce fundamental or constitutional rights, and the aggrieved party would move court with the intention that the court would direct them by virtue of a writ of mandamus to perform the duty that they have failed to perform. This writ would be used when there is a statutory duty cast upon a public office and that is not being performed or not being used in a perfect manner. The courts would, by a writ of mandamus, direct that authority to perform its statutory function. The next we move on to is the writ of certiorari. Certiorari would literally mean to certify. Now, this is when lower courts or quasi-judicial or judicial authorities step beyond the purview of their jurisdictions. By this writ of certiorari, which is issued by a superior court to an inferior court, to a tribunal or quasi-judicial or judicial authority, where the matter could be transferred to a superior court for proper consideration. The writ of certiorari is also used to quash orders which are in excess of judicial powers, especially when those are by quasi-judicial or judicial authorities. We now move on to the writ of prohibition. The writ of prohibition broadly means to forbid, to stop, or to prohibit, and effectively operates as a stay order. This writ is used by a superior court when an inferior court or a judicial or quasi-judicial body transgresses the powers vested in it or steps beyond its jurisdictions. In such a case, This writ would apply prohibiting or forbidding the lower court, the judicial or the quasi-judicial authority from exceeding its powers and proceeding in a matter. And lastly, the writ of quo warranto. Quo warranto literally means where is the warrant or by what warrant or authority. Now this writ is used when a person in public office or holding a judicial or quasi-judicial authority which he is not entitled to performs judicial, quasi-judicial or public office functions. In such case, a writ of quo warranto is used to prohibit or to question the authority of that person from an illegal assumption of public office or a usurpation of public office by any person. Now, having understood the various writs available to us, let us understand the difference between Article 32 of the Constitution and Article 226. Firstly, and this is the most important aspect, Article 32 is a fundamental right in itself, while Article 226 is a constitutional right. On this subject, we also need to understand that Article 32 is purely to protect and uphold the fundamental rights provided to us by the Indian Constitution. On the other hand, Article 226 is a constitutional right in itself, and it seeks not only to protect the fundamental rights but also the constitutional rights available to every citizen under the Indian Constitution. It is also important to note that writs under Article 32 of the Constitution can be filed only in the Supreme Court of India, and writs under Article 226 can be filed only in the various high courts of states. We then understand the difference from the point of jurisdiction. For writs under Article 32, it can be moved in the Supreme Court of India where the territorial jurisdiction is anywhere throughout the territories of India. However, in cases of Article 226, a writ can be filed only if the cause of action arises within the state under the High Court where it is being purported to be filed. In least of cases, at least the cause of action should emanate within the jurisdiction of that High Court where it is being filed. In terms of the discretionary powers, Article 32 is a fundamental right in itself, while Article 226 is a constitutional right, as we mentioned earlier. And this, being a constitutional right, Article 226 is subject to discretionary powers, while Article 32, the Supreme Court may not refuse exercise of its powers to issue writs. I do hope this provides some clarity on writ jurisdiction and the legal remedies available to us under Articles 32 and 226 of the Constitution of India.